would agree with Ms. Anderson.
All right, once the property issue is resolved, what's going to be, where are we going from here? Obviously, that sort of sounds like something's probably involved normally, I would guess, in some type of domestic relations.
I think I can answer. I can answer.
Yeah, if you would, because I don't really understand who has what property figures into the criminal case.
It is just a part of a complex fact situation. As I mentioned, Ms. Anderson or someone at the DA's office sent us material on Friday afternoon, which I was not aware of until 6 o'clock last night. I've not had the opportunity to talk to my client or review it with him. We are aware generally of what it is from conversations with Ms. Anderson, with Heath, and with law enforcement officers, but I've not had the chance to go over it with my client. When I talked to Heath this morning, his suggestion or my suggestion, I forget which, we agreed on it, was to ask the court to give us some time to take a look at that. And after we do that, we should be in a position to make a firm announcement on the resolution of the case.
Well, and that's true, Your Honor. The property doesn't necessarily have anything to do with the criminal case itself. This is just a way that we chose with the defense to operate because of the no contact order and the concerns about the defendant and the victim contacting each other. We're still way ahead of the scheduling order in this case as to the plea docket deadline. Ongoing discovery is being provided, as Mr. Files stated, and I do believe that ultimately we will be able to reach a resolution in this case.
All right. I believe the court has a grasp of what y'all are trying to do with the property. 2410867-20 State versus Josh Thomas Hooter, again, present for the court, his attorney, state's counsel present. Based on this conversation, the court is going to reset this case for Wednesday, September the 23rd at 1:30 for to determine, I suppose, whether or not it's going to be a plea agreement or go on the trial docket. I take it y'all will have all this property worked out, but Mr. Files requesting a resetting, and that's fine with the court, and the state's agreeing to it. So it's reset to Wednesday, September 23rd at 1:30. Mr. Hooter is continuing on his $5,000 surety bond on the charge of assault with family violence of the previous conviction until Wednesday, September the 23rd at 1:30, which Mr. Hooter, Mr. Files will tell you have to be back on Zoom or here in the courtroom, depending on what regulations we're operating under. On Wednesday, September the 23rd, 1:30, the court will find out what then the updated status is. Is that it, Ms. Anderson?
That's all the state has this morning, Your Honor.
Is that it?
That's all we have, Your Honor.
We're in recess.
God, should be next.
Good.
All right, go.
Court's calling cause number 241-1469-19 State versus Bracken Godby, Godbey. It's on a charge of tampering or fabricating physical evidence with intent to impair. Mr. Godby is present before the court on his bond on the indictment. Ms. Anderson's present representing the state, and Ms. Files is present representing the defendant. This is set for apparently a hearing today on some matters that y'all need, I guess. Ms. Anderson, you can go ahead. You represent the state on what this is for today.
Your Honor, I believe the defense and the state are just agreeing today to move this hearing and continue the plea docket deadline. There's just ongoing issues in this case. We are going to be able to come to a resolution, but we are definitely going to need some more time.
Okay, how much time? Then I'll ask Mr. Files. How much more time, Ms. Anderson, do you need, or do you and Mr. Files need?
I'm going to let Mr. Files speak to that as to what he thinks the timeline might be.
Go ahead, Mr. Files.
As we mentioned, there are ongoing issues in the case. Heath and I visited this morning. We did not come to a firm agreement or suggestion as to how much time. My reaction would be probably 3 to 4 weeks, and we should have a resolution of the case.
All right, let me get a date from Denise now that she has that 3 to 4 week time frame.
Heath and I are both waiting for information from other folks. And so we can't speak for them as to when they're going to get it to us. 4 weeks would probably be safe.
That is correct, Your Honor.
All right, by agreement of the state and defense, Denise has handed me a setting for Wednesday, October the 7th at 9:30. Does that suit everyone?
Yes,
Sounds
Your
great,
Honor.
Your Honor.
All right, the court is going to, I don't know if there's motion for continuance in here, Mr. Files.
There is.
You want me to grant that to this date, or I'll just grant it? I mean, I'm going to reset it to Wednesday, October the 7th at 9:30 for it's resetting for another hearing before the court to see if on that date all these matters y'all are trying to resolve have been resolved. Mr. Godby, I do need to tell you, you're continued on all of your present conditions of bonds, so you need to be sure and follow, as I'm sure Mr. Files already told you, or Mr. Harrison, you need to follow all your conditions of bond, and then you would be back, you would have to be back before the court either in person or by Zoom, depending on what we're dealing with then on Wednesday, October the 7th at 9:30, as you are this morning, and hopefully by then all these matters will be resolved. Anything else, Ms. Anderson?
No, Your Honor.
Anything else, Mr. Files?
Just hope I haven't jinxed the rest of your Zoom hearings for the day. I appreciate Mr. Harrison letting me use his office so that we could get this behind us. That's all we have before the court. May I be excused and let Mr. Harrison continue?
Does Mr. Harrison have another one?
I have several.
All right. Mr. Godby, do you understand everything's taking place here?
Yes, Your Honor.
All right, we're in recess to Wednesday, October 7th at 9:30.
Thank you, Your Honor.
Yes, sir. Thank you.
Thank you.
We're on the record in cause number 24106-99-20, State versus Gavin O'Shea Booker. Mr. Booker is present before the court on bond. Ms. Anderson is present representing the state. Mr. Harrison is present representing the defendant. All right, counsel, one of you go ahead with what we're hearing or doing today.
Judge, I'll start with respect to Ms. Anderson. We may have prematurely filed a motion for continuance last week. That is moot. We would withdraw that motion. We do have a plea agreement. We have contacted Denise to ask for a plea and sentencing date sometime off in the future. We simply did not have enough time to finalize the details and get plea papers done today, but it will be a plea for a recommendation of deferred probation.
Well,
And that's correct, Your Honor. I think that there's some restitution that they're working on to pay up front, and the state, that is part of the plea deal arrangement. And so we are willing to give the defense extra time to comply with those conditions so that we can enter a agreed plea.
So this would obviously the bottom line being, Ms. Anderson, how much time, when do you and Mr. Harrison want to agree to reset this case for? I mean, how much time do you need?
I'm going to let Mr. Harrison speak to that since it involves restitution funds. We're willing to give, several weeks here if he needs that.
What do you need, Mr. Harrison?
Judge, why don't we do this? And I need to speak with Mr. Booker privately about how much time he needs, but we do know the number, and I think we can get that done relatively quickly. Why don't we set it towards the end of September, if that's okay with the court and okay with Ms. Anderson. And if we need more time, we'll come back and ask.
Okay, the last one, I think one of the previous ones Mr. Files was on was set for Wednesday, September the 23rd at 1:30. So I'll set this one at the same time. So you and Mr. Files will just have both of them on the same day. So
Yes,
I'm going to reset this one for Wednesday, September the 23rd at 1:30 for a hearing either by Zoom or in person, depending on where we are. Mr. Booker, you are on a $33,000 surety bond with your conditions of bond, which you signed. I need to be sure you do understand one of your conditions of bond now is that you reappear before the court with counsel on Wednesday, September the 23rd at 1:30, either by Zoom or in person. That's a requirement of your bond. So if you did not appear, the court would have to take action necessary to get you here. With Mr. Harrison representing you, I don't have any question you'd be here, but I have to tell you that. Do you understand that, Mr. Booker?
Yes, sir.
All right, we'll reset to Wednesday, September the 23rd at 1:30 to see if all these matters are resolved and see if it's going to be a plea at that time. Hopefully, if it is going to be a plea, we can get it done then.
Thank you, Your Honor.
Anything else, Mr. Harrison?
Not on this case, Your Honor.
Or anything else, Ms. Anderson?
Not on this case, Your Honor.
All right, we're in recess on that case.
And may Mr. Booker be excused, Your Honor?
Yes, Mr. Booker may be excused until Wednesday, September 23rd at 1:30.
Thank you, Your Honor.
Denise, who are we calling next?
Well, I was gonna call Esmeralda Casamiro.
Okay,
Yes.
great.
She looks like she's present.
Excuse me.
All right, this is cause number 2410220-20, State versus Esmeraldo Casimiro, Casimiro, present before the court with her attorney, Mr. Brett Harrison. Ms. Anderson, State's counsel, is present, all by Zoom. All right, what have we got on this one? The indictment, I suppose just for the record, the indictment in the case charges a state jail felony offense of interference with child custody. Indictment was returned February 13, 2020. Court takes judicial notice of the contents of the file. Go ahead, Mr. Harris or Mr. Anderson, what we need to do.
Your Honor, I could probably lead on this one as well. We filed a motion for continuance on Ms. Casimiro. We have been in communication with the district attorney's office through Mr. Gilmore. I'm not sure if he's actually on. I don't see him. I see his name.
Not on. Mr. Gilmore is not on.
Okay. We provided, I think as recently as Monday, some additional information. We've been providing Mr. Gilmore some information periodically on this case. If we could set the case for the 23rd as well, that would probably be best. I indicated to Mr. Gilmore that this might require us sitting down and meeting in person and possibly with Mr. Putman or Mr. Gatewood as well at some point. This is a strange case.
That's true, Your Honor. This is an unusual set of facts, and I know that the defense has been working to gather some discovery items that they believe are material and could possibly result in, they're definitely going to affect the way this case resolves, whether it be by plea or whether it be by dismissal. And so we would agree to a reset today to allow the defense more time to sit down with us and to make sure that they have all of the items presented to us that they want to.
All right, just for the record, this 2410220-20 indictment charges Ms. Casimiro with interference with child custody, state jail felony. So the court is going to follow the request from the state and defense. Court will continue the case, reset it to that date. The last one was reset for Wednesday, September the 23rd at 1:30 for a hearing in regard to these matters state and defense have referred to. Now, Ms. Casimiro, what I need to be sure of is that you understand you're on a $25,000 surety bond. So one of those conditions requires you to be present at any court session. So under the condition of your bond, which is set at $25,000, you have to be back either in person before the court or before the court with Mr. Harrison by Zoom on Wednesday, September the 23rd at 1:30. Do you understand all that, ma'am?
Yes, Your Honor.
All right, anything else, Mr. Harris?
No, Your Honor, she's been very good about staying in touch with me and sending emails, so I have no doubt she'll be there.
My experience is your clients normally appear, but I just have to tell her that in case something goes haywire.
Understood, Your Honor.
Anything else, Ms. Anderson?
No, Your Honor.
We're in recess until Wednesday, September the 23rd at 1:30, when we'll take this case back up and see if these matters have been resolved. Recess.
Thank you, Your Honor. And as,
All right, court of call, cause number 241-06-33-20, State versus Jose Barroso, Barroso, on a charge of driving while intoxicated, third-degree felony as alleged in the indictment. Mr. Harrison, his attorney, is present. Mr. Barroso is present for the court. Ms. Anderson is present for the state. You want to waive the reading and presentation of the indictment and all the other formalities, Mr. Harrison?
Your Honor, we would. His name is correctly set forth. He understands the charge against him. He is prepared to enter his plea of guilty. I would point out that on my screen, at least, Mr. Franklin's indictment is showing rather than Mr. Barroso's. Mr. Franklin will be the next hearing.
Tell him to give me
Okay, I'm looking at the indictment in front of me. Jose Barroso, Barroso.
There we go.
All right, now the indictment in 24106-33-20 is up on the screen. Mr. Barroso, raise your right hand and have swear you insert on the plea. Do you solemnly swear the testimony you'll give before the court will be the truth, the whole truth, and nothing but the truth, and that all the plea documents which show you signed and then swore to the document are being sworn to you now, sworn to by you now freely, intelligently, knowingly, and voluntarily?
I do.
All right, Mr. Barroso, first of all, you understand your indictment, which is going back up on the screen for right now. The first paragraph of your indictment charges you with the offense of driving while intoxicated. However, the second paragraph of the indictment alleges you have 2 prior convictions for operating motor vehicle while intoxicated. I'm going to read each one of those to you. If you enter pleas of true to the 2 prior convictions alleged in that second paragraph on the screen, it will enhance your sentencing range on the driving while intoxicated alleged in the first paragraph up to that of a third-degree felony, so your sentencing range will be not less than 2 nor more than 10 years in the Texas Department of Corrections Institutional Division as set out on the plea papers. Fine may be assessed of up to $10,000. Do you understand that?
Yes, sir. Yes, Your Honor.
Have you been over all the allegations and the charge, including the allegations in the second paragraph of the indictment with Mr. Harrison, your attorney?
Yes, Your Honor.
I mean, I'm going to read these allegations right out of the indictment, out of the second paragraph to you, and then I need you to enter a plea of true or not true. It's further presented that prior to the commission of the charged offense, hereinafter style the primary offense, that on the 7th day of January 2009, in cause number 00383-250-08 in the County Court of Law number 3 of Smith County, Texas, it's alleged you were convicted of an offense relating to the operating of a motor vehicle while intoxicated. Are those allegations true or not true?
True.
It's then alleged that on the 6th day of November 2009, in cause number 0028386-509 in the County Court of Law number 2 of Smith County, Texas, it's alleged you were convicted of an offense relating to the operating of a motor vehicle while intoxicated. Is your plea to those allegations true or not true?
True.
Are you entering your pleas of true to these allegations in the second paragraph alleging prior convictions for driving while intoxicated freely, intelligently, knowingly, and voluntarily?
Yes, sir. Yes, Your Honor.
Your Honor, may I interject real quick? Mr. Barroso looked a little bit confused at that question. I just want to clarify with Mr. Barroso. Mr. Barroso, what the court is asking is it true that you're the same individual who was convicted of those 2 prior misdemeanor DWI cases alleged in the indictment? Is that true? That's what he was
Yes.
asking.
Yes, it's true.
Thank you, Your Honor.
All right, Mr. Barroso, are you entering your pleas of true to the two allegations of previous convictions for driving while intoxicated in the second paragraph just read to you by the court, freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
Has anyone threatened you in any way, promised you anything, or coerced you, made you enter those pleas of true?
No, Your Honor.
The court receives and accepts your pleas of true, and the court does find the allegations in the second paragraph of the indictment alleging two prior convictions for operating a motor vehicle while intoxicated to be true. As I've indicated earlier, Mr. Barroso, that makes the driving while intoxicated, third or more alleged in the first paragraph, a third degree felony carrying a sentencing range of not less than 2 years or more than 10 years. In the Texas Department of Corrections Institutional Division, fine may be assessed of up to $10,000. Do you understand that?
Yes, Your Honor.
Now, these plea documents are going to be going up on the screen with us doing this by Zoom. So you'll see a plea document go up. The first one is your agreed punishment recommendation. First thing I'm going to ask you is, Ms. Anderson, her signature is down where it says the criminal district attorney. Mr. Harrison has signed where it says attorney for defendant. There's a signature on the line above where it says defendant, which appears to me to be signed Jose Barroso, but I have to ask you, is that your signature?
Yes, Your Honor.
All right, your plea agreement is, if you enter a plea of guilty to the offense of driving while intoxicated, now enhanced to a third degree felony, carrying a sentencing range of not less than 2 no more than 10 years in the Texas Department of Corrections and a fine of up to $10,000. Ms. Anderson is going to recommend to the court in your plea agreement that you be assessed a sentence of 10 years in the Texas Department of Corrections Institutional Division, probated for a term of 6 years. If there was a blood draw in your case, restitution in the amount of $60 to the Department of Public Safety. Is there a blood draw, Ms. Anderson?
Yes, Your Honor, there is.
So your recommendation from the state is 10 years in the Texas Department of Corrections Institutional Division, probated for 6 years with restitution in the amount of $60 to the Department of Public Safety. Is that your plea agreement, Mr. Barroso?
Yes, Your Honor.
Is that it, Mr. Harrison?
It is, Your Honor.
Is that your recommendation, Ms. Anderson?
It is, Your Honor.
All right, now I'm going to have to go through and identify these other plea documents, Mr. Barroso. They're all going to be signed and sworn to by you. I just swore you to them. And signed by your attorney, also signed by Ms. Anderson. We've gone over the plea agreement. You tell me if you don't understand any of these documents that you've signed and sworn to, you tell me. Or if you have any questions about any of these documents, you let me know, okay?
Yes, Your Honor.
That's your plea agreement. There's an acknowledgement of admonishments, gives you the full range of sentencing, a total of 5 admonishments. You and Mr. Harrison have signed right below the 5th one. The next document's waiver of trial by jury, where you waive and give up your right to a jury trial and ask the court to hear the case on your plea of guilty without a jury. Is that correct?
Yes, Your Honor.
There's a signed and sworn to waiver of confrontation with witnesses. There is a signed and sworn to stipulation of evidence, Mr. Barroso, signed and sworn to by you, signed by Mr. Harrison. That stipulation of evidence states too, that's a written judicial confession or admission under oath by you to all the allegations and the charge in the indictment. Do you understand that?
Yes, Your Honor.
Did you sign and swear to the stipulation of evidence of your own free will, sign it voluntarily, freely, and intelligently?
Yes, Your Honor.
Next document, the court approves states to the stipulation of evidence. There's an agreement to stipulate testimony form for a waiver of appeal. You understand in that waiver of appeal, you're waiving giving up your right to appeal and waiving giving up your right to file a motion for new trial. Do you understand that?
Yes, Your Honor.
Then you've made a request for a waiver of the pre-sentence investigation, which the court has approved. There's a trial court certification of your rights to appeal. It'll be signed by the court. It's already signed by you and Mr. Harrison. It's checked and indicates, which is what this is, a plea bargain case, and you have no right of appeal, and you have waived your right of appeal. Do you understand that document?
Yes, Your Honor.
And there's a certification from you on advice you've received from Mr. Harrison on your rights to appeal. Now, understanding all of these plea documents, understanding the allegations and the charge in the indictment, do you still wish to go forward on your plea of guilty to this indictment, charging driving while intoxicated, a third-degree felony, alleged in the indictment without a jury?
Yes, Your Honor.
Do you read, write, and understand English?
Yes, Your Honor.
Have you consumed any alcoholic beverage in the last 24 hours?
No, Your Honor.
Are you under the influence today of any drug, narcotics, controlled substance, toxicant or have any of those substances in your system?
No, Your Honor.
Have you ever been confined in a mental institution or under any type of psychiatric treatment?
No, Your Honor.
Do you understand everything you're doing in court today?
I do, Your Honor.
Have you been over everything about the facts of this case as well as everything you're doing in court today with your attorney, Mr. Harrison?
Yes, Your Honor.
Is he competent, Mr. Harrison?
He is, Your Honor.
Any evidence of incompetence, Ms. Anderson?
None, Your Honor.
All right, court notes state counsel signed her consent approved of the waiver of trial by jury. Court approves the waiver of trial by jury and all the other waivers in the case signed or signed sworn to by the defendant, signed by his attorney. All right, understanding all of the allegations, the charge in the indictment, the plea agreement, all your plea papers. Do you have any questions for me at this point, Mr. Barrasso?
No, Your Honor.
All right. In cause number 2410633-20, what is your plea today to the indictment charging you with driving while intoxicated, a third-degree felony as alleged in the indictment?
Guilty, Your Honor.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, Your Honor.
Anyone threaten you in any way, promise you anything, or coerce you, make you plead guilty?
No, Your Honor.
Are you pleading guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, Your Honor.
Or are you entering your plea of guilty to the indictment because you have any type of delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No, Your Honor.
Court receives and accepts your plea of guilty to the indictment. What do you have, Ms. Anderson?
Your Honor, we offer States 1, the plea packet with signed waivers and admonishments, States 2, the signed and sworn stipulation of evidence, as well as States 3, the discovery compliance documents.
Objection, Your Honor.
With no objection, those exhibits are admitted into evidence. The court in this case, having received and accepted the defendant's plea of guilty to the indictment, charging him with the offense of driving while intoxicated, third-degree felony as alleged in the indictment. The court finding the defendant's plea of guilty was entered to the indictment freely, intelligently, knowingly, and voluntarily accepts the defendant's plea of guilty to the indictment. The court does find the defendant guilty of the offense of driving while intoxicated, third-degree felony as alleged in the indictment. Moving to sentencing, have you already offered your sentencing evidence?
I have not, but at this time, the state would offer States 4 an electronic copy of the written discovery in this case, which I can provide to the court upon conclusion of this morning's Zoom docket.
Your Honor, we've received and reviewed that and we have no objection.
States 4, all the offense investigative reports, any digitals made or results of any blood tests, all admitted in with blood test results are admitted in. With no objection, as States 4, the court in the case then, having received and accepted the defendant's plea of guilty to the indictment, finding it was entered freely, intelligently, knowingly, and voluntarily, the court finds the defendant guilty of the offense of driving while intoxicated, third-degree felony as alleged in the indictment, follows the plea agreement with the recommendation of state, session the sentence in the case at 10 years in the Texas Department of Corrections Institutional Division, probated for a term of 6 years. No fines, assessed, court costs ordered paid. Restitutions ordered the Department of Public Safety in the amount of $60 for the blood draw. Sentence is formally pronounced. Mr. Barrasso, do you understand I have a waiver where you waive giving up your right of appeal and waive giving up your right to file a motion for new trial? Do you understand those documents?
Yes, Your Honor.
Are you waiving your right to appeal, waiving and giving up your right to file a motion for new trial, all freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
Or receives and accepts those waivers or to file the papers of the cause. Now, under the judgment that'll be signed today, Mr. Barrasso, that judgment, the court has found you guilty of the offense and is finding you guilty of the offense of driving while intoxicated, third-degree felony. So that judgment will reflect that. And then the judgment will reflect the 10-year sentence in Texas Department of Corrections that the court's assessed you following the plea agreement is probated for 10 years. There's about 70 or so terms and conditions of your probation. You'll be assigned to what we call a specialized unit. I'm sure Mr. Harrison may have already mentioned this to you, but there's a specialized unit at the probation department that supervises individuals who are on probation for driving while intoxicated. There are special conditions that apply in a driving while intoxicated case. One of them would be you would have to have on any vehicle you operate an ignition interlock device, which you would have to blow in, and it would test whether or not you've got any alcohol in your system. If you do, the vehicle will not start. I'm sure you already understand that, correct?
Yes, Your Honor.
All right, there's needless to say, many other conditions. One of the most important is, and I wouldn't expect you to have any problem with it with Mr. Harrison representing you, but one of the most important, probably the number one condition is you have to report to the probation office as ordered. I tell many defendants then who I later send to the penitentiary because they don't report. But we're doing this a little bit different now. Marcella, my probation officer, is on here. Marcella, of course, he's sitting in Mr. Harrison's office, I think. So he can report right on over to probation. Is that what he's supposed to do? Does he get our date or what?
Yes, Your Honor. As soon as court is over, he'll walk over to the probation department, and we're expecting him over here. He'll sign in, new from court, and meet our intake officers.
All right, now, do you understand that, Mr. Brasso? I wish all these cases were like yours in terms of reporting, because I know with Mr. Harrison there, you're going to report. On top of that, you're sitting in his office, so you don't even have a long walk. So just go straight over to the probation department. When you get to the probation department, you'll meet your supervising probation officer. I'm sorry, Marcella, did you say who that is, or do you know now?
Yes, Your Honor. He'll meet our intake officer, Daisy or Laura, and then he'll be assigned to Laura Garcia or Lauren Florence.
All right, so when you get over there in a few minutes, Mr. Brasso, you'll meet an intake officer. They'll do some standard questioning, and then they will assign you to one of the supervising probation officer who just supervises individuals on driving while intoxicated offenses. That ignition interlock I mentioned to you, I'm sure Mr. Harris has already explained it to you, but they'll go over that with you in a certain period of time. You can't drive a vehicle if you're on probation for driving while intoxicated unless it has that ignition interlock on there, and your ignition interlock, they'll explain all this to you, has to be kept in proper working condition. Obviously, this is firm grasp of the obvious. You cannot use, consume, possess any type of alcoholic beverage or any other controlled substance. Do you understand all that?
Yes, Your Honor.
Now, I don't know, because I don't know your background, Mr. Barroso, but that'll be determined by your probation officer. They may have some outpatient treatment courses they're going to assign you to, which you will attend as terms and conditions of your probation. There are some designed for individuals who appear to have an alcohol problem. So when they see 2 prior convictions, and this is the 3rd one, they will in all likelihood be sending you to an outpatient treatment course to assist in your rehabilitation to get you off the alcohol so you don't end up in the penitentiary. Now, but you'll have about 70 or so terms and conditions, and your probation officer will go over them all with you. They do a better job than the court, and it won't take you near as long. Just be sure, let me tell you this, be sure if they go over a condition with you and you do not understand it, when they say, do you understand this condition? Don't say, yes, I do, just to finish up, because later, if they file a violation report and it shows a violation of any of the terms and conditions, upon receipt of the violation report, it's in the next 2.5 years anyway, I would immediately sign a warrant for your arrest. And no bond warrant will go out for your arrest because of that violation report. So you need to be sure and understand all the conditions. Do you have any questions for me?
No, Your Honor.
Anything else, Mr. Harris?
Judge, I guess 2 issues. One, certainly I understand, and Ms. Barroso understands that he'll have an alcohol evaluation through probation to determine if anything would be appropriate as far as further treatment. I will advise both the court and Ms. Flores that Mr. Barroso has been attending SMART recovery meetings pretty consistently. And in fact, he had his 1-year sobriety June of this year. So it's been over a year now that he's been sober. He has been doing, and this is a legal term, he's been doing fantastic. I think that'll just continue. And certainly he understands he needs the evaluation, but I suspect that he is very much on the right path.
Well, that certainly appears to the court from what Mr. Harrison has said. You're on the right path, Mr. Barroso. So it's up to the court's probation officer in those areas Mr. Harrison was referring to, but I'm sure with Mr. Harrison representing you, it probably had some influence on you going ahead and getting into these courses and successfully completing them. Be sure to tell your probation officer what you've done in that regard. Do you understand that?
Sure, Honor.
All right, just.
And Judge, I'm sorry.
No,
So that sort of dovetails into one request would be that Mr. Barroso be allowed to go to restaurants that serve alcohol.
Tell you
Again,
what,
he-
I know that's a standard request. No, it's not standard, but you often make it. But I'm gonna do this on that. I'm gonna do this on all the cases from now on. I'm not gonna grant that request until I am sure that we're not looking at any type of alcohol program anymore. I mean, any type of alcohol. If I get a report from probation that he's gone through that earlier course and they do an evaluation and they don't have any problem with him being able to go into a restaurant where alcohol is served, obviously he cannot consume any. But if they don't have any problem with it, if they're satisfied he's made enough progress, because I don't want to tempt him and then end up in the penitentiary. So I'm gonna leave that to his probation officer, Mr. Harrison.
Yes, sir.
If they don't have any problem with his condition allowing him to go into a restaurant where alcohol is served, I'd caution you on this one now. I'd caution you on this one, Mr. Barroso. If you go into a restaurant, alcohol's being served, and you sit at a table where alcohol is being served to other individuals, some of that alcohol is going to be within arm's reach. And, even though you don't touch it or drink any of it, you're going to have a technical issue that comes up about whether or not you're in possession of it if you're close to it. And but if your probation officer doesn't have any problem with it, because they're the ones that would get the violation report, I'll approve you going into restaurants, mainly based on what Mr. Harrison has told me about the efforts you've already made. So that'll be up. Ms. Marcella, if his probation officer doesn't mind lifting the restriction that would allow him to go into restaurants where alcohol is served, certainly understanding that condition, he cannot possess or use alcohol. I'll approve it, Mr. Harrison, but I don't want to say it right now until his probation officer talks to him.
Yes, sir. And then the last issue is Mr. Barroso owns a roofing company, and some of his jobs may entail travel outside of Texas. Louisiana comes to mind as one of the places. I'm certain the court is going to want him just to coordinate with probation. I just wanted to bring that up now because I think it will be an issue at some point.
Yeah, Mr. Barroso, Mr. Harrison is correct on all that, obviously. You need to talk to your probation officer about that. I can tell you that if you're doing well on your probation, the last thing we want you to do is lose your job, okay? So in all likelihood, if you go over this with your probation officer, what they're going to be looking for is they have to be sure that they know when you leave on a job, where you are going, and when you will be back. Okay, so you need to talk to your probation officer about that. If they don't have any objection to it, and I doubt they will, because we want you to stay employed. It's just that you can't drive off to Louisiana to a job and them not know about it. They've got to know when you're leaving and when you're going to get back, who your supervisor is going to be, or what job you're going to be over there working on. So just tell y'all your probation, all that. If the probation officer approve it, the court will certainly approve it. Anything else, Mr. Harrison?
No, sir. That's it. Thank you.
Anything else, Ms. Anderson? I'm sorry. Ms. Anderson, you have anything else? I wish.
No, Your Honor, I was muted.
I can understand why with the court doing all that talking.
I need that at home, Your Honor. That function.
Well, okay. You'll be if you
or the opposing
No,
party?
for my child, not for my wife, just for my child.
Oh, that was close because you were on your way to the 321st. I was going to alert Judge Wilson. All right, we're in recess.
Thank you, Your Honor.
All right, Blue, what else you got? All right, let me see if we got, Next case is cause number 24106 37-20 State versus Alderson, Aulder, Alderson Franklin, on a charge of injury to a child, elderly, or the disabled with intent to cause bodily injury. As alleged in the indictment, defendant's on a $7,500 bond with conditions. He is present before the court by Zoom with his attorney, Mr. Harrison. State's counsel, Ms. Anderson, is present. Court has a set of plea documents. Let me go ahead. Mr. Franklin, raise your right hand. I need to swear you in. Do you solemnly swear the testimony you'll give in the cause now on trial will be the truth, the whole truth, nothing but the truth to help you God?
Yes, Your Honor.
Did you hear the oath? Because I wasn't sure.
Yes,
Okay,
sir.
you heard it. All right. You haven't been sworn in, Mr. Franklin. Mr. Harrison, do you wish to waive the reading and formal presentation of the indictment in the case?
I do, Your Honor. He understands the nature of the charge against him and is prepared to enter his plea of guilty today.
All right, first of all, the indictment in the case is up on the screen. Mr. Franklin charged, as already said, I've already read it into the record in the caption. The indictment, in the name and by the authority of the state of Texas, makes allegations that, if proven, would prove the offense of state jail felony injury to a child, elderly, or disabled. Do you understand all the allegations and the charge in the indictment?
Yes, Your Honor.
And do you understand that's a state jail felony carrying a sentencing, right?
Good.
It's a third degree.
Correct.
You understand that's a third degree felony. I'm sorry, it's my mistake. It's third degree felony carrying a sentencing range of not less than 2 years nor more than 10 years in the Texas Department of Corrections Institutional Division. Fine may be assessed of up to $10,000. Do you understand that?
Yes, Your Honor.
Did I get you sworn in, Mr. Franklin?
Yes, Your Honor.
Okay, so the record reflects the defendant's been sworn in. These plea documents are going up on the screen now, Mr. Franklin. You have an agreed punishment recommendation with the state if you enter plea of guilty to this indictment, charging injury to a child, elderly, or the disabled with intent to commit bodily injury. Ms. Anderson, state's attorney, going to recommend your sentence at 5 years deferred adjudicated probation on this third degree felony offense. Do you understand that?
Yes, Your Honor.
Do you understand how the deferred adjudicated probation works with Mr. Harrison representing you?
Yes, Your Honor.
You understand if you serve out the term you're on for, or if it's extended to the full 5 years, if you serve out the term of deferred adjudicated probation you are on for, and do not violate any of the terms and conditions, the state will file a motion to dismiss the case. And then that would mean that you will not have a final conviction on your record for this third degree felony of injury to a child, elderly, or disabled with intent to commit bodily injury. You understand that part of it?
Yes, Your Honor.
I know you understand all this, but from Mr. Harrison representing you, but I have to go over with you for the record, because the other side of the road on deferred adjudicated probation, and this is a third degree felony, if any time during the period of time you are on the deferred adjudicated probation, which can be up to 5 years, if the judge of this court, if the court receives a violation report from the probation officer, yours, the court would immediately issue, based on that violation report, a no bond warrant for your arrest. Then when you turned yourself in or you were apprehended, there'd be a hearing before the judge, not a jury trial. And if the judge determined from the evidence that you had violated any of your conditions of this deferred adjudicated probation, the court could go back, find you guilty of the offense charged in the indictment, and then because you were on, I'm sorry. And then because you were on deferred adjudicated probation, if you violated any of the terms and it was proven to the court, the judge could grant the state's motion to adjudicate your case, just a legal word. Then the judge could go back and assess your sentence at 10 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. Do you understand all that, Mr. Franklin?
Yes, Your Honor.
This agreed punishment recommendation on down at the bottom, it'll be pulled up a little bit so you can see the bottom of it. There's a signature on the line of where it says defendant. Is that your signature on that line, Mr. Franklin?
Yes, Your Honor.
Right, that signature is on all the plea documents. You did go over all these plea documents, Mr. Harrison, before you signed and swore to the plea documents. Is that correct?
Yes, Your Honor.
All right, the next one is an acknowledgement of admonishments. Do you understand all 5 admonishments you signed, and Mr. Harrison, right below the 5th one?
Yes, Your Honor.
The next document's a waiver of trial by jury, signed by you and Mr. Harrison, approved by state's attorney. Do you understand that waiver? It waives and gives up your right to a jury trial, and you tell the court you're waiving your right to a jury trial and just asking the court to hear this case on your plea of guilty without a jury. Is that correct?
Yes, Your Honor.
All right, the next document you'll see is a waiver of confrontation agreement to stipulate testimony. In regard to these, when I gave you the oath, you do understand you sworn to tell the truth. In addition, you have sworn and affirmed that all the information contained in these documents you've signed and sworn to were signed and sworn to by you freely, intelligently, knowingly, and voluntarily. Do you understand that?
Yes, Your Honor.
All right, court approves the waiver of confrontation and agreement to stipulate. There's a stipulation of evidence, states two, signed and sworn to again. That's under oath, a stipulation of evidence. Mr. Franklin, do you understand that's a judicial confession under oath by you to the allegations and the charge in the indictment?
Yes, Your Honor.
Did you sign and swear to that stipulation of evidence also sworn to by Mr. Harrison? Did you sign it and swear to it freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
There's an agreement to stipulate testimony form for a waiver appeal, request for a waiver of the pre-sentence report, and then, which is approved by the court. And then a trial court certification of your rights to appeal, certification from you back to the court on advice you've received on your rights to appeal. Now, you understand you have filed a waiver of appeal. If the court goes forward, here's the case, and then follows the plea agreement and assesses your sentence at 6 years deferred adjudicated probation, this will be a plea bargain case and you will have waived your right to appeal. Do you understand all that?
Yes, Your Honor.
Or do you have any questions for the court about any of these plea documents that we've gone over?
No, Your Honor.
All right, I just got a few questions, standard questions I need to ask you. If I ask you one of these questions, these questions are pretty straightforward, but if I ask you any question you don't understand, be sure to tell me. Do you read, write, and understand English?
Yes, Your Honor.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, Your Honor.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, Your Honor.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything you're doing in court today with Mr. Harrison, your attorney, as well as everything about the facts of your case with your attorney, Mr. Harrison?
Yes, Your Honor.
Is it competent, Mr. Harrison?
Your Honor, he is competent. And if I could add one thing, the court is absolutely correct in the plea agreement, and it's listed on the plea papers that it's a 5-year deferred adjudication probation. There is one special condition of that plea agreement, and Mr. Alderson is a peace officer, licensed peace officer with the state of Texas. We have submitted his voluntary relinquishment of his peace officer's license, and that is also a part of the plea agreement. And it's reflected on the first page of the plea papers.
And that is correct, Your Honor. And Mr. Harrison's office notified me and forwarded me that paperwork that condition is being complied with. And so the state's satisfied that is being met.
I see that now, as both of you have said, only agreed punishment recommendation, special condition is checked. It reads permanent surrender of T-close peace officer license, and I understand from Mr. Harrison that's already been done.
It's been submitted, Your Honor. Yes, sir.
All right, yeah, I've been submitted, of course. Thank you. All right, any evidence of incompetence, Ms. Anderson?
No, Your Honor.
Court notes State's counsel signed her consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case signed or sworn to by the defendant, signed by his attorney. All right, now just sort of in summary, Mr. Franklin, you understand all the allegations, the charge in the indictment, the full range of sentencing, all your plea documents you've signed or signed and sworn to, is that correct?
Yes, Your Honor.
Do you have any questions for me, Mr. Franklin, about anything?
No, Your Honor.
All right, in cause number 241-0637-20, what is your plea today to the indictment charging you with injury to a child, elderly, or the disabled, with intent to commit bodily injury, a state jail felony, as alleged in the indictment?
Guilty, Your Honor.
Are you entering your plea of guilty to the indictment today, Mr. Franklin, because you are guilty and for no other reason?
Yes, Your Honor.
Has anyone threatened you in any way, promised you anything, or coerced you, made you plead guilty?
No, Your Honor.
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily because you committed this offense charged in the indictment?
Yes, Your Honor.
Are you entering your plea of guilty to the indictment because you have any type of delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No, Your Honor.
All right, the court does receive and accept your plea of guilty to the indictment, finding it was entered freely, intelligently, knowingly, and voluntarily. Mr. Franklin, all right, what do you have, Ms. Anderson?
Your Honor, we offer States 1, the plea packet with signed waivers and admonishments. States 2, the signed and sworn stipulation of evidence, as well as States 3, the discovery compliance documents.
No objections, Your
With
Honor.
no objection, stage one, all the plea documents, stage two, the signed and sworn to, stipulation of evidence, written confession under oath by the defendant, signed and sworn to, also signed by his attorney. That's approved, admitted into evidence, stage two. So stage three being the discovery of compliance, all approved, admitted into evidence by the court. The court does find that all the documents for purposes of the plea were done by the defendant freely, intelligently, knowingly, and voluntarily. The court also does find the defendant's plea of guilty entered to the indictment in this case was entered by the defendant to the indictment in this case freely, intelligently, knowingly, and voluntarily. The court in this case, based upon the defendant's plea of guilty to the offense alleged in the indictment and the court finding that the evidence admitted into the record on the defendant's plea of guilty, including State's Exhibits 1, 2, and 3, were admitted into evidence freely, intelligently, knowingly, and voluntarily, having been done in that manner by the defendant. The court clearly finds the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. However, the court does withhold a finding of guilt as to the defendant, finding the evidence sufficient to support his plea of guilty. Moving to sentencing, Ms. Anderson.
Your Honor, at this time, we'd offer a copy of States 4. This is an electronic copy of the original written discovery in this case. You'll notice there were well over 2,000 pages of discovery. This will contain the first 175 pages, which is just the original offense report.
Your Honor, we have received and reviewed that, so we have no objection. In addition, I have gone over to the DA's office to review the CAC video of the complainant, Curly Franklin.
All right, the court approves and admits into evidence State's Exhibit 5. Anything else for any other exhibits, anything else for the record, Mr. Harrison?
No, sir.
All right, the court in the case then, based upon the defendant's plea of guilty to the offense alleged in the indictment, injury to a child, elderly or disabled, intent to bodily injury. The court, based upon the defendant's plea of guilty, entered to the indictment. The court finds that the evidence admitted into the record is fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. However, the court does withhold a finding of guilt as to the defendant, follows the plea agreement, the recommendation of the state, assessing the sentence at 5 years, deferred, adjudicated probation, no fine, assessed, court cost ordered paid. Restitution is due as a term of the deferred adjudicated probation if any restitution is determined to be due by post-sentence. Illegal reason to bar formal sentencing, Mr. Harrison.
No, Your Honor.
Finding none, the court formally pronounced that the sentence. Court does find the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment, state jail felony. However, the court does withhold a finding of guilt as to the defendant, follows the plea agreement with the recommendation of the state, assessing the sentence at 5 years, deferred adjudicated probation, no fines assessed, court costs ordered paid, restitution is ordered if any is determined to be due by post-sentence. Sentence is formally pronounced at 5 years for adjudicated probation. Mr. Franklin, do you understand I've received from you a waiver of your right to appeal, also signed by Mr. Harrison, a waiver of your right to appeal, giving up your right to appeal, waiving and giving up your right to file a motion for new trial? Do you understand that?
Yes, Your Honor.
Are you waiving all those rights freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
Court receives and accepts the waiver of appeal. Court receives and accepts waiver of the right to file a motion for new trial. The court needs to make this explanation to you, Mr. Franklin. The court has followed the plea agreement, which I think is appropriate based on what I can see about this case, including the not only the allegations in the indictment, but what I would estimate as your background. The 5 years for adjudicated probation, which the court has approved, sets the sentence 5 years for adjudicated probation. I certainly expect you to follow all the 70 or so terms and conditions. However, I have to put on the record so you do understand that if you serve out the 5-year deferred adjudicated term, do not violate any of the terms and conditions, at the end of the term, the state would file a motion to dismiss the indictment, which the court would grant if there's been no violations of your conditions of probation. That would mean you would not have a final conviction on your record for this offense. Do you understand that?
Yes, Your Honor.
Now, the other side of the road, which I'm sure you're aware of from Mr. Harrison, if any time while you're on the deferred adjudicated probation, the state files a motion to proceed to final adjudication, that's a bunch of legal words, meaning the state is alleging in its motion that you have in some way violated one or more terms and conditions of your probation. And this probation officer your probation officer would have already sent, if probation officer feels they see a violation by you of any conditions, they send the judge, me in this case, the violation report. That in and of itself triggers a no bond warrant for your arrest. And then once you're in custody, there's a hearing held before the court, and it's not a jury trial. And if the court determined you had violated any term or condition of your deferred adjudicated probation, the court would grant the state's motion to adjudicate, go back and find you guilty of the offense charged in the indictment. And then, but because you were on deferred, the court could assess your sentence up to the maximum 2 years in a state jail facility and a fine of up to $10,000. You understand all that?
Yes, Your Honor.
Do you have a question?
No, Your Honor. I think,
Okay.
I'm sorry.
I just, wait a minute, let me see.
You read the,
Look like you might have a question.
no, sir, I think the terms that you gave me was for state jail, and it's a felony 3 charge.
That is one of my many mistakes.
Yeah.
It is correct that it's a 3rd-degree felony. So I have actually admonished you incorrectly, and I could see Ms. Anderson start to stand up. So to go back and say that prompt correctly, if while you're on deferred adjudicated probation, if the court receives a violation report from the probation department, the court that'd trigger a no bond warrant. State would file a motion to adjudicate. Once you were in custody, there'd be a hearing held before the judge. If the judge determined from the evidence that you had violated any term or condition of your deferred adjudicated probation, the judge would go back, find you guilty of this offense. A 3rd-degree felony is alleged in the indictment, and then the court could assess your sentence up to 10 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. Do you understand all that?
Yes, Your Honor.
All right, thank you, Mr. Anderson. And
Your Honor,
Mr. Alderson, thank you, and Ms. Anderson, thank you for straightening the court out. Go ahead, Ms. Anderson.
may I put just a couple of things on the record that we would ask for as conditions of probation?
You may.
Your Honor, normally in a case like this, you might proceed with a no contact order. The victim in this case is the son of Mr. Franklin. He is currently under orders in the 321st and working services there under Judge Wilson. So we would not want a no contact order in this case. We would want we would ask that Mr. Franklin keep his probation officer and the court apprised of what the current 321st orders are with a copy of those, and that his conditions of probation be adjusted to align with whatever the 321st has ordered. And in addition to that, Your Honor, we'd ask that you do order a post-sentence investigation in this particular case.
All those requests are granted by the court. Have you got them all, Marcella?
Yes, Your Honor.
All right, so they will not, this court will not impose as one of the 70 or so terms and conditions a no contact with the child, because that is where it should be. It's in the 321st with Judge Wilson. Judge Wilson's intermediary decree or whatever, that would cover it. And so whatever the Judge Wilson says, that would control the contact of the defendant with the victim child in this case. And I think that's what Ms. Anderson and Mr. Harrison were going to tell the court.
Your Honor, if I may, I'm glad Ms. Anderson brought that up. I was going to bring it up. Jason Mazingo is representing Mr. Franklin in that CPS case in the 21st. He and I have been in pretty constant communication since Mr. Franklin's our mutual client. And so he is represented in that case and is working the visitation and the visitation plan and the phase plan as well through CPS. One other thing, additionally, I'm glad that Mr. Franklin piped in and corrected the court as far as the admonishment as the range that he would be looking at on a violation. I am certain that's not going to happen. In fact, I've told Ms. Anderson I anticipate filing a petition for early termination when appropriate. And certainly that's not a part of the agreement, but just so that everybody is aware, I am certain that's going to be coming at some point down the road, because Mr. Franklin has been doing very well so far, and I anticipate he'll continue to do so.
Well, that's all correct. That's all correct, Mr. Franklin. You're on 5 years deferred under the statute if there have been no violations of your terms and conditions of your deferred. If you've satisfactorily carried out all your terms and conditions, the law provides that halfway through your probation, which would be 2.5 years from today, in your situation, you can file a motion for early termination with the judge. The judge then makes the determination. It's just discretionary with the judge. The judge can continue on probation for the full 5 years, deferred adjudicated probation, or the judge can grant an early termination. Do you understand all that?
Yes, Your Honor.
Anything else on that, Mr. Harrison?
No, sir.
All right, and also Ms. Anderson, let me see if I can get this part right. Fortunately, you are sitting in Mr. Harrison's office, not far from the probation department. I think you're at his office. Is that correct?
He is, Your
Yes,
Honor.
sir.
It looks like his office from where you're sitting. So all you have to do is just walk across the street, basically to the probation department, which Marcella, you already know that where that is, because it's the same place you've been doing your pretrial reporting.
Yes, sir.
When you get Marcella's getting ready to tell you who your probation officer is. When you get there, you tell him who you are. Who does he need to see, Marcella?
Your Honor, when he comes over to the probation department, if he'll sign on the computer new from court, and he will meet our intake officer, Daisy Hernandez or Laura Middlebrooks this morning, and I'll be assigned to officer this morning, Your Honor.
All right, Marcella, thank you. Do you have any questions for me, Mr. Franklin, about anything?
No, Your Honor.
All right, anything else, Mr. Harris?
No, sir.
Anything else, Ms. Anderson?
No, sir.
Anything else I left out, Marcella?
Nothing further, Your Honor.
All right, we'll be in recess. Thank all of you.
Thank you, Your Honor.
Thank you, Mr. Harris.
Your Honor, I believe that concludes the morning docket.
Okay.
Sure. Surely you can find something else to do.
Okay, that concludes the morning docket. Other than Mr. Harrison, who can now go, well, he'll be returning to his legal practice. Do you have anything else for the court that you need the court to sign, Ms. Anderson?
I do not right now, Your Honor, and I will ask the state if we could be excused until this afternoon.
Okay, you're
Judge-
excused until this afternoon.
Judge, I could probably find some expunctions or early terminations or bond amendments or something.
Or 55 motions for continuance. Whichever way you want to go.
No, I prefer to resolve our cases timely and efficiently. Thank you, Judge. I'm leaving now.
Let me go ahead and go off soon while I can still keep a straight face. We're in recess.
Thank you, Judge.
Thank you, Your Honor.